Good afternoon, everybody, and welcome to the webinar. This is the fifth and final webinar in this series on the psychology of claims. Today we're discussing the effective use of ADR. I'm Alex Johnson. I'm a partner at Freeths. I specialise in engineering and construction law. Joined again by John Fotherby, a partner at Kingsfield Academy. And we also have Wayne in the background, who is doing his thing as usual and keeping this show on the road. As I said, this is the final webinar in our series. We've been discussing the psychology of claims. Previously, we talked about value, cost, and damages, and the difference between those concepts. And in this webinar, we are exploring the topic of ADR, Alternative Dispute Resolution. Now, this concludes this particular series. We've gone from looking at what's necessary to make effective claims. We've looked at the requirements for making extension of time claims. We've looked at delay expert analysis, and we've also looked at what's needed to make money claims. So we're concluding this series by considering how claims are ultimately resolved and what kind of outcomes can be achieved through ADR and the various methods of ADR. As usual, the webinar is for 1 hour. As usual, we have a ton of content. But we will endeavour to answer questions at the end if we have the time. So if you think of any questions or issues that you're having as we go, please note them down, submit them, and Wayne in the background will send them to us and we'll try to answer them at the end of the hour. Otherwise, if you have questions that you'd like to discuss with us, feel free to email us directly. And there's also a further announcement on questions at the end of the webinar. But let's start today with a poll. So Wayne, if we can call up the first poll. Who knows about a dispute that was resolved by the following methods? Litigation, arbitration, mediation, expert determination, or negotiation? Tick more than one that apply if that's relevant. We're just trying to gauge what kind of experience everybody has. Okay, so we've got some results coming up. Okay, so litigation and arbitration, plenty of experience. Negotiation, very high, 83%, that's good. And then mediation and expert determination, some experience as well. So overall, that's good. That's a good spread of experience across those various areas. I think what this tells you is there are many ways to resolve disputes. And there are certainly more than just traditional options, which are litigation and arbitration. And in fact, the majority of cases don't actually ever reach a trial or a final hearing. Cases resolved by trial are, in my experience, in the vast minority, just a small percentage of the total cases that certainly I've ever dealt with. So this means that the majority of disputes are resolved by other means, even if litigation or arbitration proceedings have been commenced. And I think there's probably several reasons behind this, but I would make the following observations on that. First of all, I think everybody knows and appreciates that going to trial or a final hearing in arbitration is time consuming and it's expensive. It's not an underestimate to say that it can take years and it can cost millions of pounds. So this process can be pretty draining to a business because it's not only the hard costs of paying lawyers and paying barristers, paying expert witnesses, but there are also the soft costs of diverting people in the business away from their usual roles and away from winning new work. So overall, there's a very substantial cost. And going to trial or a final hearing is generally a last resort. It's generally the final option when everything else has failed. So the courts will actively encourage parties to resolve their disputes without resorting to litigation. The courts don't want every single case in the land going through their doors. So they try to convince parties to take an alternative path, and they will make, for example, adverse cost awards against parties that fail to participate in ADR. I think the other thing with litigation and arbitration is we always talk about it in terms of winning and losing because it's by its nature an adversarial process. But I think for cases that have gone to trial, it's never actually that simple. And in my experience, even the party that wins a court case usually doesn't feel like a winner because by that time they've spent so much money, they're tired, The whole process has been a battle of attrition, but I don't think they feel anything other than relief generally. And also, certainly in the English courts, the losing party will pay the winner's costs. So the winner never receives all of its costs back in terms of the money it spends to fight the case. A winning party is generally doing pretty well if it recovers 60% of its costs. So it means that there's always a substantial percentage of unrecoverable costs, even where the party is successful, even where it wins the trial. In arbitration, similar principles, but of course, additionally, parties pay for the arbitrators and also the venue, and often those things are particularly expensive. So all of these factors, I think, should point commercial parties towards other ways of resolving their disputes, and hence ADR has been a key feature of dispute resolution for many years. And so the majority of cases that don't go to trial reach some kind of a settlement, and most likely that's through some kind of ADR process, whether it's formal or more informal. But before we get into all of that, the webinar series has been about the psychology of claims. So I think to understand how to settle disputes effectively, we should understand what causes the disputes in the first place. So I'll hand over to John. John, what do you believe causes disputes?
Well, Alex, let's first have a poll on this subject. Wayne, can you bring it up, please? What are the leading causes of disputes? Do you think they are force majeure, multiple changes, orders, delays, disruption, or human behavior? And you might think it's a combination of any of those. So let's see what your thoughts are.
Interesting.
Yeah, interesting result. Yes, I see that delays are a problem.
Yeah.
Which is not unusual. Right, okay, thank you. I see that. I think from my perspective, disputes are caused by people, not events and circumstances. It's their responses to the events and circumstances and how they manage them or mismanage them that then leads to dispute. And inevitably, there's a great deal of emotion involved in any dispute situation. And I guess the leading emotions are anger and fear. And they tend to lead to defensive and offensive actions, which then manifest themselves in the dispute resolution process. And yet, as Alex has just mentioned, with winning and losing, we try to resolve disputes by considering the events and circumstances in the context of facts, contract, law, and other issues, but in the absence of anything to do with emotions or behaviours. And yet that's that's where we are, it's the root cause. In arbitration and litigation processes, there's a great deal of emotion on both sides as well. You know, the legal teams, they're really uptight. Witnesses of fact are very nervous about what they're going to be asked to give evidence on and cross-examined and all that sort of thing. And expert witnesses, well, probably it's the ego that's the issue that gets in the way there. I am an expert and I am right. Yes, except you are not and you are wrong, is usually the sort of reaction from the other side. So judgments and awards in litigation and arbitration are invariably made on a win-lose basis, which means one party will be happy and the other party will be miserable. And that's going to be the loser, no doubt. And they're also possibly surprised, disgusted, contemptuous of the process, and then they try to appeal. So the whole process hasn't resolved in a resolution anyway. Claims are often an expression of one party wanting their day in court and to be heard, and to obtain some recognition of the problems and the plight that they've been confronted with. And it's not always about money. Let me give you an example. Many years ago, I worked for a plumbing contractor. We had a young and highly talented up-and-coming foreman plumber, and he resigned from the company. And the general manager was disappointed and shocked, so he called him into the office, and he thought he was actually leaving to go to a competitor because they'd offered him more money. So the general manager offered him a lot more money, and he declined it. What he actually wanted was the general manager to say thank you for the work that he'd done for the benefit of the company. And he left the company. So I bet you're thinking, what's this got to do with disputes in engineering construction? Well, it's about understanding the real issue before trying to find a resolution. If you don't get to the real cause, you will never find a proper resolution and lasting resolution. So we have to look at the human behaviour element in any event. So, Alex, I don't know whether that answers your question, but I've got a question for you. You've talked about ADR. What do we mean?
Yeah, good question. Let's do definitions. So there's no real accepted definition of ADR. Funny enough, in the US, ADR covers all dispute resolution methods except court proceedings. So it would include arbitration. Whereas in the UK, ADR typically covers all dispute resolution other than litigation, i.e. court proceedings or arbitration. So we tend to refer to court and arbitration, or litigation and arbitration, as formal dispute resolution in the UK, and everything else is ADR. So we'll be working with the UK's definition today so as not to cause too much confusion. And I'll discuss some of the main ADR processes later on, but I think first it's important to understand that whichever ADR process is chosen, there are advantages and disadvantages to ADR, to the principle of ADR. So I'll talk about some of the advantages to begin with. The definite number one advantage is that it saves time and it saves costs compared to litigation or arbitration. I think we're all aware litigation and arbitration can take months, if not years, to conclude. So compared to that, ADR can usually be arranged and put together and carried out in a much shorter time period. You're looking at weeks or a few months, I think. So consequently, ADR is generally cheaper than litigation, and it's certainly cheaper than arbitration. So undertaking the ADR early on in a dispute, I think even if it's unsuccessful, it can have some benefit because it reduces the potential for cost sanctions or case management sanctions that might be imposed on a party if it refuses to engage in the ADR to begin with. And refusing to engage in ADR, particularly in the English courts, is frowned upon greatly because they don't want you to come to court. They want you to settle before you get there. I think another benefit is creativity. I think ADR allows parties to think outside the box in terms of potential resolution of the dispute. Because dispute resolution doesn't always have to involve money, of course. There are many other things that are usually at stake or commonly at stake. So there could be other commercial drivers that are important. Most parties are in contractual relationships that last longer than the contract that they're currently in. There's a broader relationship. They may be doing other projects. There may be potential to win future work. So all of these can be relevant factors in any dispute settlement or resolution. And ADR doesn't have the same win-lose paradigm that litigation and arbitration has. And so it allows parties to focus more on bringing about a solution, not arguing over the problem. So I think a key advantage is that parties are free to tailor the processes because they're flexible generally to suit their own needs rather than just having someone impose a decision on them, which can be unsatisfactory, of course, and for reasons as simple as, you know, the judge was in the wrong mood on the day you got to the trial. You can't predict those kind of outcomes, but they can be quite relevant. ADR processes are confidential, so compared to court, which is on the public record, that's often a key benefit. Parties are protected by without prejudice privilege in ADR, which is privilege that allows parties to speak freely, and it will aid potential settlements. They can have discussions where they're not to be concerned about the fact that those discussions can be subsequently referred to the court they can't be because they're privileged. ADR maintains relationships. I think unlike litigation and arbitration, ADR is generally non-adversarial. So I think it increases the likelihood of any ongoing commercial relationship. Litigation and arbitration are really the end of a relationship, or seriously damaging to any commercial relationship, because it's not a pleasant experience. It's all about winning and losing. It's all about taking money out of one person's bank account and putting it in your bank account. Whereas ADR is not the same. It can be more flexible, and everybody buys into the solution in ADR. Whereas, as I said before, court and arbitration, it's simply a decision that's imposed. I think prospects of settlement in ADR are generally considered to be pretty good. The Centre for Effective Dispute Resolution, CEDR, suggests that over 80% of mediations that are referred to it result in settlement. I think even if parties don't settle on the mediation day itself, mediation tends to pave the way for at least a future discussion, and it often paves the way for a future settlement. And the mediator can even remain involved in the process if the parties want that. So I think even if there's no settlement, I think ADR tends to narrow the issues in dispute, and it tends to test the strengths and weaknesses of the parties' arguments, and it allows the parties to actually discuss with each other. Now, there's always a lot of correspondence that gets thrown between parties, but they never really have a real conversation about things. And I think ADR allows that to happen, even if ultimately it doesn't go anywhere. Disadvantages. I think if ADR doesn't result in a settlement, clearly there is some delay. Clearly there's some wasted costs. But I think that always has to be balanced against the probability that the ADR is likely to be successful, which I think is well above 50%. And so even if there's no settlement, the ADR tends to have a fair amount of upside. I think parties are sometimes scared that ADR means they have to show their hand in terms of the case or the case strategy if it doesn't settle. But I think that fear is generally allayed by the fact that the ADR processes are confidential and privileged, and ultimately a party can choose what it says at ADR. I don't think there's any requirement for a party to divulge its entire claim strategy in an ADR. It can choose what it wants to say. But what's important is that the court or the tribunal don't ever get to hear that because it's privileged and confidential. Enforcement can be a problem. ADR processes don't always result in binding settlements. So I think parties are very well advised to enter into a settlement agreement that will formalize the terms of any agreed settlement and make it binding, because you cannot enforce a non-binding ADR decision. Delay to trial. I think that's an issue. It's difficult enough to get a trial date often, and so if ADR is pursued, particularly late on in the litigation process, then it can get in the way of that process and it can delay the trial. And I think courts are unlikely to allow a stay of proceedings to accommodate the ADR. So typically the ADR and the court processes have to occur in parallel. And I think finally, maybe the biggest disadvantage that parties perceive is that it's a sign of weakness. I think parties sometimes think that a willingness to engage in ADR is a sign of weakness or a lack of confidence in their own case. But I think if the court's strongly encouraging parties to do it, that's not really a true disadvantage. I think a party that maybe isn't confident in its case would refuse ADR, whereas a party that is confident, what has it got to lose? So ultimately, I think the best ADR outcomes generally arise in situations where the ADR method suits the particular dispute. I think it's important to point out that many things form a dispute. There's what's at stake, there's the position of the parties, there are the issues in the case, etc., etc. So there's no one size fits all when it comes to the ADR, and it's often the case that a bespoke solution is the best. So I'll hand to John. John, do you have any practical examples of bespoke ADR solutions that led to successful outcomes?
Well, several, yes. But I actually believe that the best way to resolve disputes, bar none, is by negotiation. And I think that's reflected in the results from our poll, with 83% of people experienced in such settlements. But I also think that effective negotiation in this industry is a rare occurrence because of the win-lose basis that is frequently adopted as a negotiation strategy. And that's positional negotiation as opposed to interest-based negotiation. And if you remember in the earlier sessions, we referred to William Ury and getting to yes on interest-based negotiation. And I think, you know, you don't have one or the other. You have to have several strategies for negotiation for them to be really effective. But I'd like to give an example of where we shifted from very much a positional negotiation to an interest-based negotiation in a project that I was involved in. So we'd been acting for the contractor for some time on this project. Both parties, the owner and the contractor, had legitimate claims against each other. The whole thing was heading towards arbitration. And we decided, the two parties decided, that they'd have one last go on neutral territory in a hotel to try and find the settlement. So everything was booked and we went there. And the meeting was attended by the respective managing directors and other senior people from the respective organisations, as well as the lawyers and everybody else. So we got quite a jamboree there. And we set two days to decide for these negotiations and sort of made it a bit time limited. And on the first morning, as you might imagine, we walked through the parties' respective arguments and such like on these claims. And we were about half an hour away from lunch, and the owner's side stood up and said they wanted to present their claim numbers to us. So we said, okay. And this PowerPoint slide appeared on the screen in immense detail, lines and lines of numbers and calculations, and it was evident that there were some subsequent slides that went into ever more detail. And I thought, oh dear. Anyway, we let this this guy present his stuff, and you know, we quietly acknowledged it without admitting anything. And as we approached lunchtime, I said, you know, let's break and go for lunch. And got our side out, not to the lunch table, but into a corner. I said to the MD, we cannot possibly engage with this lot in a discussion on numbers because it's going to go nowhere. Their position is one thing, our position is another. I suggest that after lunch, we have a discussion about what our respective interests are. Our side agreed that, and the next move was to then go and talk to the owner's lawyers to see how they thought about it. Well, in a nutshell, they thought very little about it. And their first position was no, as was their second and their third. But eventually we got there and they said, well, okay, but this is going to be a waste of time. So I said, look, we give it 45 minutes. If we don't get anywhere, then all we've done is wasted 45 minutes, and that's it. And we've been here since 8 o'clock, and we're going to be here till 10 o'clock tonight, so what does it matter? So eventually we went back into the room and we said, this is what we're going to do. We're going to have 2 flip charts at the end of the table. A couple of guys are going to write on these, and I'm going to ask you all to just respectively shout out what your interests are in coming to a settlement with these claims. Everybody agreed? Yeah, a bit sort of hesitation. So it's okay, let's go. And the first person to speak was the managing director from the owner's side. And he said, our #1 interest is to work with the contractor again in the future. And our managing director on the contractor's side said, yes, and we want to work for the owner. I thought, that's it. 1.25 hours later, we'd got 2 flip charts on each side full of interests. And at that point, the 2 managing directors left and spent the next 2 or 3 hours coming to a deal. And it concluded. By 8 o'clock that night, we had signed heads of agreement and we went off on our separate ways. I happened to go to the airport that night with the financial director from the owner, and he said to me, I was totally against this. I thought it would be a complete waste of time. And he said, I'm just amazed that we were able to reach an agreement. I think it was very effective. I've done it several times. and I found that it works. I don't know if that example helps or not to illustrate the point. So, Alex, it seems to me there's some confusion regarding the different types of ADR and when it's appropriate to use them. And in fact, only last week I was contacted by someone who said they wanted a mediator to act between a contractor and an owner to help them resolve claims. And when I dug a little bit deeper, what they actually wanted was someone to do some expert determination. So not very close together at all. Could you describe to us the differences then? You talked earlier about the principles.
Yeah, that's quite a funny example, because those are very different processes. So I think, you know, we do kind of throw these terms around, but I am aware that maybe they're not always perhaps as well understood as people may think. So yeah, let's go through some of them. I think first of all, I'd make the observation that whichever process is adopted, the aim of ADR is generally the same. So that it's to enable the parties to reach a settlement with the assistance of a third party who's not involved, who's independent. I think, as we'll look at later, and as John mentions, I think there's no reason why parties can't reach a settlement together without a third party, but I think there are blockers that parties generally put in front of themselves from doing that. And John's example there was a great example of how the blockers came off, because he thought outside the box and did something differently. But I think it often takes a third party, whether they're evaluating or whether they're facilitating or whether they're doing both, to guide the parties towards some kind of settlement, because parties tend to get stuck in the same way of thinking, you know, positions rather than interests, as John has mentioned. So I'm going to split these ADR processes into non-binding and binding. So first of all, I better explain what I mean by that. Non-binding ADR means that the parties have to go to court or to arbitration if they're unsatisfied by the outcome of the ADR process. So where ADR outcomes are non-binding, they should be formalized by a settlement agreement between the parties to make them binding. Binding ADR is different. It means that the outcome is final and it may be enforced by the courts or in arbitration. And probably going through the examples will help you to appreciate the differences here. So non-binding ADR processes, probably the key and most obvious one is mediation. Mediation is where the parties come together to explore options for resolving the case, and they attempt to reach settlement with the assistance of a neutral third party who's the mediator. That's the theory. I think mediation remains very popular, and certainly its proponents report a very high success rate in terms of reaching a settlement, either on the day or afterwards. Mediation can be facilitative, or it can be evaluative, or it can be a combination. Now, evaluative means that the mediator can make certain evaluations or certain decisions on the claim and the merits of the claims and give his view. And I think in engineering construction cases, where mediators are commonly quite experienced QCs, quite experienced barristers, their view tends to carry some weight, because they can tell you what a court is probably going to think of a problem. So if there's a particular legal issue or a factual issue that is preventing a settlement, some mediators will come to a view on it and say, well, look, the court is likely to think that you're wrong, or they're likely to think that you're right. And that can help clear the way to a settlement discussion. They're not making a final decision on anything, they're just telling you what they think. But it can focus the parties towards the settlement rather than the issue. And so facilitative is a different technique. Facilitative is simply trying to get the parties to come together towards a resolution. And facilitative techniques can be as simple as saying, well, look, you've already spent £1 million. You're claiming £5 million. It's going to cost you another £1 million to get to the trial. You can see how they try to get settlements to, you know, to get parties to see sense, I suppose, in situations like that. 80% success rate according to CEDR. I think in my experience, what's interesting about mediation is in my experience, they don't typically settle on the day, but they do settle thereafter, generally. There was one case where the parties were so deeply entrenched, they hated each other. They didn't even want to speak to each other, never mind mediate. And it was a task just to get them in the same room. And they didn't stay in the same room together for very long. But the lawyers were talking with each other and passing messages through the mediator. And at the end of the day, a commercial offer was made by the other side, which frankly was amazing because it was more progress than had been made in 18 months of dispute. So that shows the power of, just coming together and trying these things. Even where the parties hate each other and they don't particularly talk, an offer was made, which was real progress. I think success depends heavily on the mediator. You need to get the right mediator. If you have a heavily technical, complex case, then somebody who's effectively trying to horse trade isn't going to be the right solution. And mediation, it relies on position statements. So a party is setting out a position. These are not the same as legal submissions or claims. There's no power in mediation to compel the production of evidence, for example. So mediation isn't really interested in the truth. Mediation is interested in the solution. So it can be less effective if a party thinks that it's going to find out the truth or it's having its day in court. Mediation is not a day in court. Trust me, both involve lots of waiting, but they're not the same. Mediation can be very effective. I'm going to give a really off-the-wall example here. In the UK, millions of pounds were spent on litigation that arose from the Alderhay hospital scandal, which was where a health authority was sued by parents for retaining the organs of premature babies without the parents' consent. It was an awful thing. But the litigation went nowhere over many years. But the issue was resolved in a mediation eventually, and a settlement was reached in a matter of weeks. And the key to it was that what the parents really wanted, rather like John's example earlier, was an apology and some closure. It wasn't really about the money. So this has nothing to do with engineering construction, of course, but it confirms what John said earlier, that disputes are really about people and emotions. And mediation, I think, is particularly successful at drawing those things out, getting to what parties really want, whereas a trial or a hearing doesn't do that. A couple of other non-binding techniques, well, one more. Early neutral evaluation. I don't see this being used very often, but in this technique, parties will appoint an independent person to provide a non-binding opinion on merits, which will evaluate facts, evidence, and law, which relate to a particular issue or even the whole case. And the rationale is having an opinion early leaves the parties free to negotiate the outcome. So it can be quick and cheap, and it provides a good reality check early on, I think. It's particularly effective, of course, if the evaluator is a judge, because they can tell you what they will think or what a judge will think later on. It's well suited to cases that are otherwise deadlocked by a point of principle or a question of law that are open to interpretation. But I think a major disadvantage is that if the evaluation heavily favours one party, it can lead to entrenchment because that party will just become confident and think, well, I may as well carry on, which is completely the opposite of what it's trying to achieve. So it's not well suited where you've got complex issues of fact or large complex disputes, for example. Binding ADR processes, expert determination, as John said, that's what the parties really wanted when they asked him. It's an informal process that produces a binding decision. So an expert is appointed to determine a particular issue, which is usually technical in nature, and it's usually, the expert is usually an expert in that particular field. It's an evaluation, it's not an arbitration, and an expert is an expert, not an arbitrator. So it's particularly good when you have highly technical disputes which hinge on a particular technical issue, and it can result in saving costs, and it can give quite a lot of confidence to the parties in that the decision is going to be made by the right person, whereas a judge or arbitrator are not specialists in particular fields. They are, by definition, judges and arbitrators, and they rely on the expert evidence which is given by others. I think it can be unpredictable, which is a disadvantage. I recall an expert determination that I once did where we asked a barrister whether 12 events were compensation events, thinking that they all were, but he decided that 6 were and 6 weren't. Wasn't particularly good, but I suppose it was an even-handed decision. Fortunately, in that case, we'd agreed it wouldn't be binding. So I think expert determination is probably best not used where there are extensive factual issues, because experts don't have powers to compel evidence production and get to the truth, rather like mediators. And similarly, it doesn't really lend itself to purely legal disputes unless your expert is a lawyer. Generally, the decisions can't be enforced without court or arbitration proceedings. I'll mention adjudication. It's a curious creature of English law, to say the least. It was introduced by legislation in 1996 called the Housing Grants Construction and Regeneration Act, and it gives parties to construction contracts as defined the right to refer disputes to adjudication. Even if the contract doesn't fall under the statutory regime, adjudication can be agreed as a contractual process instead, and it often is, even in international contracts. An adjudicator gives a quick decision on disputes that arise under the contract. An adjudication is basically a very, very skinny, quick arbitration. It's limited to typically limited to exchanging written submissions and evidence, and it's concluded in about 28 days or shortly thereafter, and it can be very cost effective for that reason. The intention of adjudication was to prevent cash flow problems. So it was recognized that subcontractors in particular who were owed money often couldn't afford to pursue the money because it would take them too long to get the money back through litigation, by which time they would have gone out of business. So it was designed to get the money fast, effectively. And so it has been criticized as being rough justice, which is certainly true. It's also been criticized, and again, not inaccurately, as pay now, argue later. And that's because the decisions are binding until the court says otherwise. And so typically adjudications are done under time pressure by the nature of it. You can't get a full hearing on all the issues. You can't amass all the evidence in this time frame. So parties are under pressure to put things together quite quickly, and that can lead to a fairly rough and ready decision, quite frankly. And the costs of adjudication are not usually recoverable, so parties have to bear them themselves. But there are a number of other ADR techniques, med-arb, conciliation, mini-trial, which we won't explore today, but they're aimed at the same thing, which is bringing about a settlement. I would also say it's important to check the contract, because the contract might specify a particular ADR process that has to be used, in addition to any other provisions such as discussions between parties, maybe project management level, senior management level, and then any formal dispute resolution clause. So, as I mentioned to begin with, I think all ADR methods have advantages and disadvantages, but they're all basically a third party facilitating an outcome. But what if we told you that parties can do that for themselves? As John has already hinted at, parties are quite capable of achieving effective commercial settlements without a third party or a formal ADR process. So never discount negotiation, which is obviously where parties attempt to reach a settlement without the third party being there at all. And again, these can be protected by without prejudice privilege, because they are an attempt to settle the case. And so this privilege will apply, and it means that the content of the negotiations are not disclosable to a court or a tribunal. And negotiation, I think, is often overlooked, but it's by far the most flexible, the quickest, and the least expensive method of ADR out there. The parties are in complete control of the process. They can end the discussions at any time. They can decide how they want the discussions to be played out. They can basically do whatever they like. And negotiation can work at any point in a dispute, even on the doorsteps of the court, which frequently happens. I think the major disadvantage of it is the prospect of a deadlock, because there's no third party in the room to break the deadlock. And it's certainly difficult for complex and multi-party disputes, for example, where negotiations aren't one-on-one. But overall, I think parties probably pay too little attention to negotiation as part of a dispute resolution strategy, and they focus on the more recognized methods of ADR. But I do think effective negotiation is key. So, John, how can parties ensure that settlement negotiations are effective?
Well, I think first of all, as human beings, we're all negotiators, whether that's in relationships or with your kids or parents, with friends and acquaintances, people at work, whether we're dealing with authorities, whether we're buying and selling things, and so on. So we're involved in negotiation to get what we need almost daily. However, when we're involved in complex negotiations over issues of technical, contractual, legal, commercial issues, then we need to raise our negotiation skills significantly to be able to cater with those complexities. So as a company at Kingsfield Academy, we run negotiation training programs. And I'm just going to address two of the key issues that we focus on. First of all is negotiation strategy, and secondly is preparation. And I propose to do that by citing two examples that I was intimately involved in, which I hope will illustrate the points. We'd worked for this contractor for very many years, in an EPC contractor in industrial plant development. There's two projects at different times, and they were quite similar projects. They were stock in trade.
I think we've got a bit of a pause on John there, unfortunately. John, are you back with us?
Where did it?
You're back in the room, I think, John.
Yeah, is that working?
Yeah, I can hear you.
Is that? Yeah. Can it?
Yeah.
Is everybody hearing me? Yeah.
Yeah.
Do you know where I got to before I was blocked? So,
You
two
started.
projects very similar. Hey?
You just started and then you went.
Oh, right. Back to the beginning. And this is like snakes and ladders. Right. I'm talking about two projects for the same contractor that were very similar in character. Stock in trade, similar size, 600 million euros type thing, similar sort of contract period, 34 months, something like that, and similar sorts of issues regarding claims and counterclaims and that sort of thing. So, and we as a business were involved with this contractor on these projects in helping the project teams put together the claims. And in those processes, there'd been exchanges backwards and forwards between the contractor and the owner on the claims at the, excuse me, at the project level. And then we got to a point where there was a need to escalate this to a senior management level to try and find a solution with the respective owners. So in the first case, we had a situation where the two executives had made a meeting arrangement with the client on a particular day. They'd arranged that meeting at 11 o'clock in the morning. The job was based in the Middle East, and they were coming down from Europe to Middle East, and they arrived overnight. And we had the full team assembled, ready to meet them. They arrived in the office about 9 o'clock. They did the usual rounds with the people in the office, and by that time we were at sort of 9:15. And then we sat down to discuss the claims and where we got to. The only thing they were interested in was the money. And we had some discussions about who was going to accompany them to the meeting, and so on and so forth. So no, we're going together and we're going to get the money. And we were talking about a claim of something in the order of 150 million. So it was not small beer. So off they went. And when they got to the meeting, they found that the owner's executive had all these key project leads with him. And they didn't want to talk about money. They wanted to talk about the principles of the claim. So the guys were back about 12 o'clock, somewhat with tail between legs, because they'd gone nowhere. I think the real lesson there is that the only strategy was confined to a negotiation on the numbers, on the presumption that the owner had accepted the arguments that had been put forward previously. And there may have been some agreement on those, but you can't guarantee that that's going to be the starting point for the other side. Yeah. They didn't go with anybody that could talk about the project and the problems and the claims, and they didn't know about those because they hadn't had sufficient briefing, because they hadn't allowed sufficient time. So it was something of a disaster. Ultimately, the thing was settled, not by good negotiation necessarily, but by some good fortune that came our way, and we were able to get a resolution ultimately. Had we not had that, the thing would have been very, very difficult to deal with. Contrast that with the other project. Another senior executive from the company, different one, was involved. He commissioned the project team and myself to get a strategy together. So I went across to the site, met the team, and I've been involved in the claim previously and knew them. So we started from the point. I asked the question first off in the meeting, what are your interests in finding a solution to this problem? And we listed down all those interests that we could identify. And then we started to look at the issues, and we were pretty familiar with those. The next issue was who will be on the other side and who is going to be the obstacle to the problem. And we identified that. And then we identified who we needed on our side to accompany the executive to help him and support him in these negotiations. And we agreed on that. And in between times, he was still wherever. We were contacting him by video link and discussing these. So everybody was in tune. And then we got together a day before the negotiations, and we ran through the rehearsal. And I was told that the person on the other side that was the big problem was their lawyer. Not surprisingly, really, Alex. And that the chief operating officer, who was really leading the whole thing on the project level, relied immensely on that lawyer. So there were some issues that we really disagreed with, and we thought that he was making the running on these, and we weren't sure. So my job was to neutralize him, not physically, even though that would have been a pleasure. Anyway, I started by asking questions, knowing what the answers were, and he nicely confirmed to me, without really realizing it, what I wanted to know. The impact of that was I was able to attack it, his principles, not him, deal with the issue, and need no answers. And the effect of that was to cause the COO's shoulders to shrink, because he was bothered about where this was going. He'd no answer to it. And we moved on with the discussion. And at one point, our managing director said to the CEO on the other side, okay, I think we ought to go and have a discussion. We settled it within about another 6 or 7 hours of negotiation. And I think the difference is the preparation and that approach to an inquiry with the other side of where they are, and knowing who's on the other side and how to deal with them. So yeah. That's my experience, a couple of my experiences anyway. Yeah. So Alex, what do you think about that? What have you got to add?
Yeah, I think that's really interesting. I think you raised an interesting point, which is, should your lawyers be present in commercial negotiations? And frankly, my preference is to stay out of them, because I think commercial negotiations are a chance for parties to speak freely. And lawyers are paid to protect people. We don't generally, I think, criticizing the entire profession, I don't think we generally add too much to commercial negotiations, because I think sometimes we can be quite restrictive or blocking. And I think, frankly, even in mediations I've done, the progress gets made where the principals talk head to head, when the lawyers aren't in the room. And that's the same for commercial negotiations, really. I think to break the deadlock, it's not generally the lawyers that do that, although there are situations where that does happen. But I think it's better that the parties talk between the two people that are most qualified and able to talk, which really unlocks things. I think ultimately, in terms of ADR, I think no matter which process you adopt, a negotiation, I think, is best if it can be done and conducted and managed effectively. I think timing is key. There's certainly pressure from the courts, as I've mentioned, for parties to engage in ADR as soon as possible, and even at the pre-action stage. I think that's laudable, but my experience is that ADR or negotiations are typically more effective when something is at stake, or a certain point has arisen, or you've gone so far in a case, because it's only then that the parties are really looking for a different way out. Whereas I think at the beginning, they're just investigating the case. They're probably annoyed that it's arisen in the first place. They haven't spent much money yet, relatively speaking. So it's not a natural point to try and resolve things, I don't think. And I think if the court didn't push so hard, maybe parties wouldn't try and resolve things that early on. I think parties generally dig in to begin with. And there's almost, I think, sometimes lip service paid to the requirement to, participate in ADR early on. But I think later on in proceedings, when you've really got into the, the attrition of the litigation or the arbitration, parties are getting tired and they're getting more amenable towards ADR. And I think even if you have the best case in the world, once you get to that stage of pre-trial preparation and then the trial, that's a significant amount of money that is yet to be spent, and a sizable proportion is unrecoverable. So I think that's when reality tends to sink in, which is, well, there's always a chance of losing, no matter how good the case is. As I said earlier, the judge may just be in a particular mood that particular day. The witnesses of fact realize that they have to take the stand and be cross-examined, which isn't fun. The barrister really is going to charge you £100,000 for his brief fee. These things tend to focus minds and get parties to look for another way out. And I think that's where ADR can be quite successful. And it's, timing is everything. So let's quickly wrap up on arbitration. John, assuming all else fails, what are your views on arbitration as a forum for dispute resolution?
Do you really want to know my views? I think arbitration has always been regarded as a speedier, less formalistic, less expensive process for resolving disputes. But I think due to the need to win and the ever-increasing inventiveness of the various players, arbitration has become more formalistic, it's become less speedy and more expensive. And of course, the lack of right of appeal has remained. And I think what we've seen is a not so mini industry has been spawned from the misery of dispute. ICC, in my view, is a money-making machine, basically, as are the arbitration centres around the globe. I mean, that's what they're there for. I'm not criticising them, I'm just saying what it is. And I can't complain. I've been a consultant and made a lot of money out of this, so it's it's the way things are. And so does everybody else that's involved in the process, the lawyers and the experts and everybody. But unfortunately, it's the disputant parties who pay the bill. So I raise the question, could those financial and human resources be put to much better use? And I think that's a real question that people should ask themselves, particularly in view of what you were just saying. And a few years ago, a well-known London QC, who's a judge and arbitrator as well, not named, you and I know him, was running an arbitration course attended by one of my colleagues. And he said to the delegates, if the parties to the engineering construction contracts actually read and understood the arbitration clause and the contracts and managed their projects in a way that ensured they would be able to meet the requirements of arbitration in terms of establishing a case on evidential-based facts, then in all probability, there will be no dispute and hence no arbitration. And I think I agree with that. So what's your thoughts on that?
Yeah, I think you're definitely right about the costs, and the costs of ICC arbitration in particular. I mean, it is prohibitive. Arbitration and the difference between court is, you pay for the arbitrators and you pay for the venue. You don't pay for the court. You don't pay for the courtroom. So arbitrators' fees are pretty substantial, and the ICC rules state that they're a percentage of the sum in issue. So clearly, if you have a $500 million arbitration, any kind of percentage of the sum in issue is a pretty good day for the arbitrator. I think in defense of arbitration, on a 3-arbitrator panel, you get to pick your arbitrator. You don't normally get to choose your judge. I think despite the costs of it, it's popular and it's effective as a way of resolving typically high value and mega disputes. Litigators generally work on the 1 to 4 rule, which is you spend 1 to get 4 back. So if your claim is £10 million, it's proportionate to spend up to £2.5 million to fight it. But the problem is engineering construction cases are complex. whereas you could easily spend more than £2.5 million on a £10 million claim, and then it tends to be disproportionate. But I think in arbitration, where you're looking at claims running to several £100 million, that's generally not an issue. If you're claiming several hundred million, even spending a few million on the arbitration, you are well within the typical rules in terms of spending one to get four. So proportionality is, I think, important there. But that's not to say, I think even on the biggest arbitrations in the world, parties should look for commercial settlements. There's often more at stake than just money. There's often more at stake than just winning an arbitration. There's a reputation, there's commercial relationships, there's political issues in these bigger cases. And so arbitration doesn't take those things into account. It's just simply a decision on the case. And of course, it always has an advantage over litigation because it's confidential rather than on the public record. So John, we're speeding towards our conclusion. Over the course of the series, we've explored the psychology of claims. How would you summarize the psychology of settlement?
Well, I think that in any engineering construction contract, conflict is almost inevitable. There's too many issues where the parties can disagree. But I think that healthy conflict is positive and unlikely to end in dispute, whereas unhealthy conflict is not and has the potential for dispute and is often not resolved without embarking on dispute resolution. So what do we mean? Healthy conflict means the parties are able to have an adult conversation about challenging situations that arise on their projects and which result in agreement that both parties are able to endorse and enact. In this context, it's a question of mindset regarding the parties' respective status in particular. Is this a master-servant relationship, or is it a contracting partnership relationship? Regardless of the type of contract, it's how they see each other. The distinction is often there from the outset, but don't be fooled by the sort of statement by either or both parties that we are one team. This is a myth, a complete myth. Now, unhealthy conflict is likely to preclude adult conversations, whereas healthy conflict is more likely to embrace them. In a healthy conflict situation, the language of the contract is very likely to be less important, whereas in an unhealthy conflict, the contract is the party's safe haven from which they're able to shoot at each other. Now, once embroiled in tit-for-tat contractual legal argument, the potential for amicable settlement diminishes quite rapidly. And just moving on to something else that happens often during the project, and particularly in the early stages, statements by contractors. We cannot serve a claim notice because we do not want to upset the client. This is really a nice excuse for not dealing with issues. And it seems to me to signify a real master-servant relationship in which the adult conversations are not possible and unhealthy conflict lingers beneath the surface throughout the project. And it often breaks out due to the most trivial of issues that then become full-blown disputes because it's gone. Healthy conflict and adult conversations enable the parties to raise, address and resolve challenging issues throughout the project. The settlement of conflict and the avoidance of dispute through these conversations begins on day one and continues throughout the project.
Yeah.
Now, where the dispute resolution process is commenced, it's my view essential to understand why and how that dispute arose, because this has the potential of cutting to the quick of the dispute. If you don't know why and how, you've got very little chance of solving it. And it often goes back to the human behaviour issues. And yet the tendency is to spend all our time and energy discussing what and very little about why. I've found countless times that when I've been briefed on a claim situation for which the owner or contractor requires assistance, that the claim asserted is really the presenting issue and not the real reason for the claim or the dispute. And to get to that, you have to dig down and examine the parties' behaviours throughout the project. So in answer to your question, the psychology of settlement, sustainable settlements are more likely when human behaviour is accounted for in the process. You can't ignore the facts. but you've got to deal with the human behaviour elements as well.
Yeah, thanks, John. That's good. You know, if this series gave you cause to think of any questions, then, you know, do get in touch with us and talk to us about those questions. I'm going to announce our next webinar as a result of this series, in which we've discussed an awful lot of topics and we've covered a lot of ground. We've decided to have an additional webinar, 4th of November, 12 noon UK time. It's called The Psychology of Claims, Your Questions Answered. And what we're going to do is we'll take the opportunity to answer questions that you may have based on our webinar series, to share knowledge between us and to discuss real life situations and where these issues occur. So we'll announce all the details of this webinar shortly, but what we're going to invite you to do is to submit your questions in advance. We'll prepare the answers. We'll discuss them in our session. It can be on anything that we've discussed in this series. It will all be confidential. No names will be mentioned. Nobody will know who asked what question. And we'll collect together questions based on themes and topics. And we're hoping for a more interactive format so that we can actually talk with you and you can talk with us. So it'd be great to see you there. That's the 4th of November 2020, and we'll send details about that. Also, we're putting together a pack of information based on these webinars. It should be pretty useful information. If you're interested in receiving it, just email us and let us know. We'll send it to you. And then look out for early 2021. We're going to do these additional webinars on time and cost claims, which will run as 2 sessions, where we'll also be doing some live cross-examination of willing volunteers, which I think will be interesting. So again, details will come out about those. We'll have about 30 places available for that, and we'll charge about €95 per person per event. So it won't be like these free webinars publicly available. And again, if you'd like further details on that, let us know. And finally, many thanks for joining us. Many of you have joined us for these webinars on the psychology of claims. Thank you for your support, and hopefully we'll see you on the 4th of November. And until then, we'll say goodbye. Thank you.
Yes, goodbye and good luck with your projects.